Every early morning run, every walk across campus at dusk, every ride back after dark. That's why She's Birdie created the Birdie Disc, a clip-on safety light and personal safety alarm for the students stepping into a whole new level of independence. On sale for back to school. Buy two, get one free. A new campus, a new city, a whole new routine. An exciting life stage, but a vulnerable time for many women. The Birdie Disc clips hands-free to her backpack strap, sports bra, or bike. 3 LED modes make her visible to drivers in low light, and unlike an ordinary running light, it has a built-in 130 decibel siren, so if something feels wrong, one press brings every eye to her. Get your college girl the Birdie Disc during the back-to-school sale. Buy two, get one free. Visit shesbirdie.com. That's SHESBIRDIE.com.
Hello and welcome back to Fuck That. If you're new here, don't forget to hit subscribe so that way you never miss an episode. Real quick, I apologize if you hear a background hum. It's super hot. Normally I try to record without my air conditioner in the background, but it's too hot to do that, and unfortunately it's going to be too much to noise gate out, so I'm so sorry. Please don't hate me. This episode is going to be a little bit different in terms of formatting. So today I'm going to cover the Katie Phang lawsuit. She's an independent journalist that is currently suing Todd Blanche, the Attorney General and the head of our Department of Justice, over the Epstein files, specifically violating the Epstein Files Transparency Act. So what I'm going to do is I'm going to give a little bit of a background on the Epstein case real quick because we all know about it. It doesn't need to be rehashed. Everything that happened with Maxwell and the subsequent legislation that came from it. And then I'm going to go through, this lawsuit is still occurring. There have been a lot of really important updates, actually, over the past few days. So I'm going to go through specific documents that cover a lot of really pertinent information to the Epstein case and specifically this law. And I'm going to kind of do a multi-part and follow this as it goes. So it's not going to come to a conclusion today. And I apologize for that, but it's still occurring, so I'm just going to kind of update as we go. Let's start with a broad brush overview of the Epstein case. And if any of you have any questions, of course, you can reach out to me and I can either clarify some things or provide some credible resources. But the Palm Beach Police Department began investigating Jeffrey Epstein, the disgraced and thankfully no longer with us financier, in 2005. And this all started after the parents of a 14-year-old girl reported that he had paid her for a massage. Police found that Epstein used assistants, some of them minors, to recruit other girls for massages that often became sexual. Palm Beach police believed that the state charge did not reflect the extent of his conduct, a tale as old as time. So the case was referred to the FBI. And federal investigators identified additional victims and subsequently prepared a draft 60-count indictment. 60. Unfortunately, that indictment was never filed because money buys you anything. So in 2007, federal prosecutors in South Florida entered into a non-prosecution agreement with Epstein. This is referred to as his sweetheart deal. And if you really want to go down a rabbit hole with this, I would implore you to look into Alan Dershowitz. One of my biggest flexes is that he blocked me on Twitter back when I was on Twitter. He was a law professor at Harvard. So in 1997, this anal fissure wrote an op-ed arguing that statutory rape laws are outdated. Really quick, I actually want to note that Virginia Giuffre, may she rest in peace, was one of the women that has made accusations against Alan Dershowitz. He's never been charged with anything. So he argued that having statutory rape laws, we should either lower the age. At one point, he argues lowering it to like 14 or just getting rid of them altogether. And I'm going to read you 2 quotes because respectfully, I want you guys to get fired up about this. In the op-ed, he states, "This raises a fundamental question about the continuing legitimacy of statutory rape laws at a time when sex involving teenagers is so rampant. and prosecution for statutory rape so selective. Mind you, he was born in 1938. This was written in 1997. He's a few shakes away from being eligible for the Denny's Early Bird Special senior discount, talking about teenage sex. He continues, "It's obvious that there must be criminal sanctions against sex with very young children." I'm just going to say that one more time. Very young children. I don't know about you all, but I don't think that that's something that's occurring in that age group. He continues, "But it's doubtful whether such sanctions should apply to teenagers above the age of puberty since voluntary sex is so common in their age group." And again, he suggested that we should either waive it completely or lower it to 14. Just to kind of tie this all together, because he specifically mentioned puberty age, I'm looking at Cleveland Clinic right now. I can add this into the show notes, but I wanted to get a gauge of an age range because I know it can vary for several years. According to Cleveland Clinic, which is reputable, puberty for girls usually starts between 8 to 13. Boys, it's a little bit later, 9 to 14. So just to put how sick this is into perspective. And since I'm throwing people under the bus, I want to note that the key prosecutors and officials involved in this, the United States attorney at the time for the Southern District of Florida who approved this secret plea arrangement was Alex Acosta, and the chief criminal prosecutor for the Miami U.S. Attorney's Office, Matthew Menchel, as well as the assistant U.S. attorney who led the initial sex trafficking investigation, Marie Villafana. Alan Dershowitz, again, was a defense attorney who joined Epstein's legal team, and he helped orchestrate this entire thing. Prosecutors in South Florida entered into this non-prosecution agreement with Epstein. In exchange, he agreed to plead guilty to 2 state charges, register as a sex offender, and serve 18 months in county jail. In exchange, federal prosecutors would end their investigation, and then they agreed to not prosecute Epstein, 4 named co-conspirators, or any potential co-conspirators in South Florida. The victims were never told about this agreement before it was signed. Epstein ultimately served less than 13 months, and if you look into the time that he served, he was approved for work release, and they let him leave the jail for up to 12 hours a day. This could be looked at as a fucking vacation, if you ask me. Fast forward to 12 years later, so this all occurred in 2007. Now we're going to skip to July of 2019. Federal prosecutors in New York charged Epstein with sex trafficking minors and conspiracy to commit sex trafficking minors. The indictment alleged that he sexually abused dozens of underage girls in New York and Florida, and also paid some of these underage girls to recruit other underage girls. As we all know, Epstein died by suicide, allegedly in federal custody on August 10th of 2019, before the case went to trial. The Department of Justice's Inspector General later found that there were several serious failures by jail staff. If you remember in the news, maybe about a year or so ago, we ended up getting footage of outside the jail cell. There were a lot of inconsistencies. And these inconsistencies included pretty significant things like missed checks and falsified records, but they claim that there was no evidence found that contradicted the FBI's determination that his death was not the result of a criminal act. Ghislaine Maxwell, his partner for several years of his life, as well as arguably the most significant co-conspirator that we know of to this point, she was convicted in 2021 for helping Epstein recruit and groom underage girls. She was sentenced to 20 years in federal prison.
Every early morning run, every walk across campus at dusk, every ride back after dark. That's why She's Birdie created the Birdie Disc, a clip-on safety light and personal safety alarm for the students stepping into a whole new level of independence. On sale for back to school. Buy 2, get 1 free. A new campus, a new city, a whole new routine, an exciting life stage, but a vulnerable time for many women. The Birdie Disc clips hands-free to her backpack strap, sports bra, or bike. 3 LED modes make her visible to drivers in low light, And unlike an ordinary running light, it has a built-in 130 decibel siren, so if something feels wrong, one press brings every eye to her. Get your college girl the Birdie disc during the back-to-school sale. Buy 2, get 1 free. Visit shesbirdie.com. That's SHESBIRDIE.com.
At this point in the episode, we're going to get a little bit political, but regardless of what side of the spectrum that you're on, right, left, somewhere in between, just stick with me. All right? Because there's a lot of misinformation, miscommunication, and I think if you know that meme, I think it's like 2 or 3 Spider-Men and they're all like pointing at each other. There's a lot of that going on, and I think we have to collectively put our heads together. All right? I'm going to start with addressing why the Biden Department of Justice did not release all of the Epstein files, because we're going to get into the Transparency Act that was signed when Trump was in office. He's still in office, so with him in office. Why this didn't happen before and everything else. All right, just fucking stick with me. I can hear some of you guffawing. All right, just chill. Take a deep breath. Ghislaine Maxwell was convicted in December of 2021, and she was not sentenced until June of 2022. Justice moves at the pace of a fucking snail, apparently. She appealed the following month. The Second Circuit did not affirm her conviction until September of 2024. That's almost 3 years after she was convicted. And it did not deny her request for rehearing until November 25th of 2024. And all this means that she still had time to ask the Supreme Court to hear the case when Biden left office, so her conviction was not fully final. The Supreme Court did not decline to hear her case, thankfully, until October of 2025. How this works is a lot of the material that people refer to as the Epstein files was tied directly to Maxwell's criminal case. The discovery was covered by a protective order that restricted the DOJ from publicly releasing it. Grand jury records were separately protected under Rule 6E, which prevents government attorneys from disclosing grand jury material unless a very specific exception applies or a court authorizes the release. So, unfortunately, at this time, the DOJ couldn't just take the evidence from Maxwell's case and upload it while her conviction was still being challenged. It could still review and release records that weren't covered by these set restrictions, and it could have asked the court to modify the protective order, but the pending appeal prevented the kind of full release that people were demanding from Maxwell's case. I want to pivot towards the legislation that we're talking about, which is at the crux of this lawsuit, and that is the Epstein Files Transparency Act, and that was formally introduced on July 15th of 2025 by 2 people on opposite ends of the political spectrum. Democratic Representative Ro Khanna out of California and Republican Representative Thomas Massie out of Kentucky. The bill was sent to the House Judiciary Committee, and that's where it went absolutely nowhere. Massie and Khanna resorted to a discharge petition, and the discharge petition essentially allowed members of the House to bypass leadership and force a bill onto the floor as long as they could collect 218 signatures. It's basically what members use when leadership does not have intention of allowing a vote. And this is where things really begin to get messy, and there is a lot of back and forth and drama. House Speaker Mike Johnson openly opposed the effort, and he pushed a separate resolution supporting an investigation that was already being conducted by the House Oversight Committee. So Massie's like, this is a fucking placebo, which is fairly accurate, to be fair. The resolution did not require the DOJ to release the records covered by the bill. The discharge petition opened on September 2nd, and it eventually received signatures from every House Democrat and 4 Republicans, and by doing so, all 4 of them essentially blew up their political careers. Thomas Massie, who, as we all know, had one of the most expensive campaigns against him just a few weeks ago, and he lost, unfortunately. There were, I think, $40 to $60 million most of which were AIPAC money to fund his opponent, and he did lose. Lauren Boebert, she was pulled into the Situation Room, which is where we talk about situations, not things like this, to be pressured into not signing. Why are people being threatened and pushed out of political office for signing a petition that would allow the release of the very papers and files that the president and his cabinet ran on? Let's just sit with that and let it marinate in a very uncomfortable way. Then we have Nancy Mace. She was all for it. And Marge, good old Marjorie Taylor Greene. As you all know, Marjorie retired. I believe she finished her position in January of this year. And she said that she had to retire for herself and for her safety because after she publicly backed this discharge petition, she started getting threats against her life and her family's life. That brings the total of signatures to 217. We needed 218. More drama that was happening at this point. There was a special election that was held in Arizona on September 23rd, and a woman named Adelita Grijalva won, and she was the last signature that was expected to come in to bring it to 218. Grijalva had already said that she would sign the petition, but Mike Johnson did not swear her into office for 7 weeks. So during that time, the petition kind of just sat there, waiting to get that last signature. And finally, Grijalva was sworn in on November 12th, and so she signed it that same day, and they officially had the 218 signatures that they needed to force a vote on the floor. This really changed the political situation very quickly. Massie and Khanna did a lot of good with this bill. I actually am surprised pleasantly and moved by how much work they put into this, particularly Massie. I really admire a man that's just willing to put everything on the line for a situation that he knows deep down needs to be solved because it's so fucked up and it's so deeply intertwined into our government. What I loved about this is because they've tried to bring this to a vote already several times and that people voted no is they thought to themselves, all right, if we make this a public vote, it's public record, people will know who vote no, and then they'll judge those people for voting against this, right? I'd like to think so, but thankfully we didn't have to make that consideration. And this is where the timeline kind of becomes accelerated. You just speed run into where we're at now. Because in November of 2025, the House Committee on Oversight and Government Reform released 20,000 pages of documents that were obtained through a subpoena to Jeffrey Epstein's estate. And a lot of that contained really important information that had not been seen before regarding private email correspondences and records that ended up kind of reviving this scrutiny for his high-profile associations. And we'll get into all of that, but once the discharge petition officially reached the 218 signatures, Trump and his admin realized that unfortunately this vote could no longer be avoided. It had to take place, which meant that the political situation was changing very quickly. It was at this point that Trump told Republicans to support the bill. Mike Johnson stopped fighting the vote and brought it to the floor before the discharge process formally required him to. He, at this point, described the bill as a political exercise and then voted for it because, in his words, nobody wanted to be accused of opposing transparency. So at least he was honest about that part, I guess. Not the, oh, we're not going to oppose this because children were trafficked. No, that may have been, I should figure out who writes his speeches because I feel like they could use some help. I don't know. On November 18th, the House passed the Epstein Files Transparency Act by a vote of 427 to 1. That's it. So Senate passed it unanimously without a hitch. The House of Representatives ran into a snag by the name of Clay Higgins of Louisiana. He was the sole member of the United States House of Representatives to vote no on the Epstein Files Transparency Act. So I just figured that I would let you all know the name of that demon. Okay, so like I had mentioned, it passed unanimously in the Senate on the 18th. There was only one nay. What this means is I'm going to attach a link to this in the show notes, but we have a veto override process. And the way that works is if you have a supermajority vote on something like we did with this, only one person said nay out of 400 and something, 427 to 1. That means that it's a supermajority and cannot be vetoed. Now, of course, there's a way around this, a few ways around this. One of those ways could be a pocket veto. There's a way around this, but I digress. This was a supermajority. I think Trump was kind of backed into a corner and knew that he had to sign it. And so he signed it, and the bill became law on November 19th of 2025. So the bill becomes law on November 19th, and essentially the law gave the Attorney General, who at the time was Pam Bondi, 30 days to publish all unclassified Epstein-related documents held by the DOJ, including records held by the FBI and federal prosecutor's office in a searchable and downloadable format. This covers the investigations and prosecutions of Epstein and Maxwell, flight and travel records. Of course, we want to know who took a plane to the island, plea and immunity agreements, which, as I've mentioned earlier in the episode, if you remember the earlier sweetheart deal, this is something that's very important to this case. Epstein's detention and death, people named or referenced in the investigations, internal DOJ communications about charging decisions, and records concerning evidence that may have been destroyed, altered, deleted, misplaced, or concealed. Now, there are ways that the DOJ could redact certain information because if you're thinking about the scope of the case, that would 100% be necessary because there's unfortunately going to be very sensitive material involving minors. So that's number one. That goes without saying. Number two, a really big thing is anonymity. A lot of these women still go by Jane Doe. So you want to make sure, especially if these documents become public, that we're still protecting these survivors. They should be at the forefront of what's on our mind when it comes to keeping people safe before we let these materials come to light. They also added to that, like I said, CSAM, identifying victims, images depicting death or abuse, properly classified information, and material that could potentially interfere with an active federal investigation. Okay, that all makes sense. It all seems fair. Here's something critical that they added to the law, which I really respect Massie and Khanna for. Massie said he did this specifically because he knew MAGA very well. They made sure that they added a specific prohibition at the DOJ from withholding information because its release could embarrass somebody that they knew they were friends with. Anything that could damage a reputation or create political problems for a governmental official, public figure, or foreign dignitary. Now, the DOJ was also supposed to explain every single redaction, and the redactions were only supposed to be applied to those specific categories. Within 15 days of completing the release, the Attorney General had to provide Congress with a report that identified what was released, what was withheld, the legal basis for the redactions, and every government official or politically exposed person named in the published material. The month following the act becoming a law, so December of 2025, the DOJ did release a small number of files, nothing really substantial, and this led to a lot of criticism from both parties, the left and right. So they're like, all right, guys, we hear you, whatever, okay? We hear you, peasants, shush. Here's what we're going to do, guys. We're going to release 3 million pages in January of 2026, and your mind is going to be blown. It's going to be so thorough. It's going to answer all of your questions, and we're definitely not going to remove any co-conspirators or perpetrators. Because we want to be transparent. That's why it's called the Epstein Files Transparency Act. Duh. So within that release, they also included 2,000 videos and 18,000 images. And the Department of Justice acknowledged that a total of 6 million pages might qualify as files required to be released. Then on January 30th, there was another release, and they said that that would be the final one, and that once they released all of these documents, they would have officially met their legal obligations. The release mentioned a few different public figures. It did lead to some scrutiny of their activities. Individuals who were seen in the files include Epstein's assistant, Leslie Groff, accountant Richard Kahn, Donald Trump, his wife Melania, lawyer Darren Indyke, and sex trafficker socialist Ghislaine Maxwell. It also included a really important figure who will come up, modeling agent and alleged sex trafficker Jean-Luc Brunel, who offed himself in prison because he couldn't face his crimes, as they seemed to do. So now let's summarize this big, gigantic mess. The Epstein Files Transparency Act became law on November 19th of 2025, and that gave the DOJ 30 days to release the covered material. The Department of Justice missed that deadline. Small releases continued through December and January, and on January 30th of 2026, the DOJ dumped more than 3 million additional pages and announced that it had now released roughly 3.5 million pages and was in full compliance with the law. The real fight over the Epstein files really started in February 2025 because this is what they all campaigned on, when newly confirmed Attorney General Pam Bondi started promising that the Trump administration was going to fully release the files. On February 21st, Bondi was asked on Fox News whether the DOJ would release Epstein's so-called client list, and she said, "It was sitting on my desk right now for review." 6 days later, the DOJ rolled out what it called Phase 1 of the Epstein files, including binders that were handed to conservative influencers outside of the White House during a photo op, if you will. The problem was that most of the material was already public. Bondi then said that she had originally been given only about 200 pages, and she had just discovered that the FBI's New York field office had thousands more that had not been turned over to her. So she ordered Kash Patel to give her everything and promised the DOJ would release the remaining material after reviewing it and protecting victims' identities. Then, in July, the DOJ and the FBI abruptly announced that there was no incriminating client list. Like at all. Like everything that they were talking about for a really long time, that isn't a thing. They claim that there's no credible evidence that Epstein had blackmailed prominent people and that no evidence that would support investigations of uncharged third parties existed. They also announced that no further disclosure would be appropriate or warranted, so within about 5 months, Bondi went from publicly teasing a client list and promising more files to DOJ saying that there was no client list and essentially declaring the release finished before it had even begun. Now, that obviously did not end the issue. Congress eventually passed this very act that we're talking about today. Again, that deadline was December 19th. It came and went, and they missed the deadline. They did continue to release some of the material, but the December material immediately raised a lot of questions about what had been withheld or removed, because at least 16 files reportedly disappeared from the DOJ's website shortly after publication, including an image showing photographs of Trump in Epstein's belongings. And after people noticed, the DOJ ended up restoring that image and said that it had been temporarily removed because officials were checking whether any victims appeared in it. During the January 30th, 2026 dump, over a month beyond the date, the DOJ released more than 3 million additional pages and announced, like I said earlier, that it had released 3.5 million pages and it's all complete, despite having identified more than 6 million potentially responsive pages during its review. So where did those pages go? And also, the redactions were a fucking shit show. The redactions were supposed to protect the victims, but I guess it really depends on what your definition of a victim is, because theirs is different than ours, I think. Sensitive information belonging to victims and other women appeared throughout the release, including photos. Reuters later found at least 6,250 instances where names, addresses, phone numbers, birth dates, photographs, or other identifying information had been left exposed, affecting at least 177 women. Some of that information remained online even after the DOJ was told about it, and women subsequently reported harassment, stalking, and threats. On April 2nd of 2026, Pam Bondi was ousted by Trump, And a Reuters report noted that Trump had become increasingly frustrated with her performance, especially after her handling of the Epstein files. He was reportedly angry that she was not moving quickly enough to prosecute political opponents and other people he wanted targeted. So Epstein was not the only issue, but it was a major one. But at this point, Pam had spent more than a year making herself the face of this entire fucking disaster. Todd Blanche, the man in the lawsuit, eventually stepped up in a temporary role, although he was just confirmed about a week or two ago. And Todd Blanche thought it would be a good idea to go on television and say that the DOJ's review of the Epstein and Maxwell sex trafficking case is over and that we should all move on from it. His position was that the DOJ had reviewed the evidence and could not just start inventing criminal cases where prosecutors did not believe prosecutable evidence existed. Victims and their families, obviously, as well as their attorneys, strongly disagreed with this idea that the matter was finished, particularly while questions remained about what DOJ had actually released and why a lot of the information was still missing. At this point, they had been summoned to court. Pam had gotten summoned to court, and they needed to explain the redactions because what you had was pages and pages and pages and pages, like somebody just took a black Sharpie and gave it to a toddler and said, draw all over these pages kinds of redactions, without any explanation behind it. But then things weren't redacted, like CSAM or victim information. So by the end of April, the DOJ had missed the deadline, pulled files after releasing them, completely fucked up redactions involving actual victims, and they faced questions about missing records, and they were also still trying to gaslight us into thinking that they had complied with the law. Which brings me to Queen Katie Phang. Katie Phang is an attorney and independent journalist who had been covering Epstein and the release of the files extensively. On April 27th of 2026, she sued acting Attorney General Todd Blanche, arguing that DOJ saying it was done did not magically mean it had actually followed the Epstein Files Transparency Act. And while many people in the legal field thought that the suit would be dismissed, it was anything but that. And I'm going to leave you on a cliffhanger, but there's going to be a lot of episodes in this. Don't worry. The next episode is basically almost done, so it will come out the same week that this episode releases, so you don't have to wait a week in between. The next episode, we're going to jump right into the lawsuit, starting with the complaint. Thanks for listening. If you liked what you heard today, please like, review, subscribe. You can find me on TikTok. I do weekly live streams, fthatpod, Instagram, fthat_pod. If you want access to all of my episodes early and ad-free, as well as bonus episodes and archived episodes, find me on Patreon, fthatpod. Website is fthatpod.com, and there is sweet, sweet merch on there.
This episode sponsored by She's Birdie. You know that little wave of relief when someone texts, "Made it home safe"? That's exactly the feeling She's Birdie was designed for. The Birdie Disc is a clip-on personal safety light and alarm made for everyday moments where visibility and attention matter most. Night walks, early morning runs, parking garages, college campuses, dog walks, travel. It features bright flashing LED light modes, a built-in flashlight, and a 130 decibel siren that can quickly draw attention if something feels wrong. And because it's lightweight, rechargeable, TSA-friendly, and easy to clip onto jackets, bags, strollers, bikes, or keychains, it actually fits into real life without being bulky or complicated. More than 4 million people already trust She's Birdie for added peace of mind. For the people you care most about, daughter, partner, friend, student, or parent, this is one of those simple things that can make a real difference. Go to shesbirdie.com. Again, that's shesbirdie.com.
This episode sponsored by Homebase. Homebase is built for small businesses trying to do it all: the neighborhood coffee shop, the local gym, the family-run restaurant. With Homebase, you can schedule your team, track time, run payroll, and manage hiring from one easy app, so you can spend less time chasing timesheets and more time running the business your customers love. More than 150,000 small businesses already use Homebase to keep their teams on track. Start free at joinhomebase.com. Homebase, built for small businesses that do it all.